about over Daily Update TV. So according to the Office of the Special Prosecutor and the PRO, we didn't come be say Kino Forata were involving the Attorney General Ayini say or handed some part of the case and some part of the arrest and as the prosecution process to Attorney General in the area of say Kino Forata Bebagana. Na start prosecution. Na yenkuti how he said he will involve the Attorney General office so that the OSP can able to work effectively and get Ofori prosecuted. Yenkuti, God bless
you. Because those procedures can even be done in Ghana in 1 hour. If you go to the urologist department at Kolebu here, it can be done in an hour and you just go home. That is why the office has maintained that unless Mr. Ofori has a certified medical report from Mayo that says that he is incapacitated, and here many people don't understand it when we say incapacitated. What we mean is that if somebody says he is sick, it is not a bar not to come before police. The only time you can refuse not to come to police or police will oblige you is when you are unable to say walk. You are bedridden. So we want to know whether Mr. Ofori since February, he has been on hospital bed in Mayo Clinic till 2nd June, or Mr. Ofori since February has been traveling. We want to know. Because the only time you cannot travel is when you are bedridden. And the OSP is saying that, and that's the context many people don't understand that. We are saying that until we see a medical report that says that Ofori cannot travel, that is the only time we may accept and give him some time, because then incapacitation counts everything. But to simply say that you are sick so you can't come, do you know how many people in Ghana are going to Kolebu for diagnostic procedures on cancer every day, and yet they are standing trial in court, they are appearing before the police people? Because the only time you go is the time you have the appointment. In between those times you don't have appointment, you have to appear. And Mr. Ofori will have to appear. That is why we are now enforcing his appearance. So we have done the right thing by placing him on interpool red notice, which means that we want him arrested. And then we have also started the extradition process. We have written to the Attorney General. It will go through the Attorney General to Foreign Affairs so that he can then be repatriated back to Ghana. So in the long and short, Ghanaians, all the office is doing is now ensuring his attendance. That's all.
But I'm sure that's what you were responding to earlier, that based on this act, specific to criminal cases, you could, this is section 5K, you could have explored, and it is lawful, you could have explored the video conferencing option and even written to the authorities, the United States authorities here in Ghana.
And most especially, the act is not limited to accused persons. It's not correct.
He should show not limited to accused persons.
When you are in investigation,
so you don't need to have accused Ken Ofori or being an accused person before this video conferencing option is explored.
It's not true. Let me answer you, and I'll repeat. I think that the people of Ghana heard me very well and they understand what I've said. Mr. Ofori has not been arrested.
Yes, I think that's clear.
There is nothing else we will do. You don't know why we need him. Law enforcement agency will write to you and say that we need you for interview. You don't know what happens when you enter the law enforcement office. You have no idea what it is that the OSP wants to do. And I'm saying that we can't take any statement. Who even told Ghanaians that?
Can you, look, listen, can you point to the law? Point to the law specifically.
I know you want to have your day, but
no, I'm just saying point to which section. Which section says that it's only when somebody's been arrested that you can use the Act 807.
Of knowledge.
No, don't go there.
Who told you Martin people? And as you've gone on this side, who told you that the OSP wants elevate? Hold on, if I can finish. Who told you that the OSP wants
No, but the specific question was to, I think there was a question that was posed to you. It's not about Martin People specifically. It's a question that was posed to you. Now, what is the specific provision of the law? Does the law back what the position that you are espousing?
Hold on. There's too much talk. I can't can't hear because I'm on the phone. Those of you in the studio have the advantage of having louder voice and clearer. So if you can let me finish because I'm on the phone.
So I'm asking a question about what specific provision of the law.
I said you have called the provision, and I told you that. Who even told you that the OSP wants Mr. Fureta to write a statement? Who even said that?
But if you don't need him, then what are you doing? What are you doing?
If you don't need him to write a statement, then what's all this about?
Who even told you that it's a caution statement the OSP wants? Because the law is very clear. A person can come to you and decide that you will not even talk.
Yes,
I'm saying that USP says that it wants Mr. Fureta in person. And he has offered to us that he wanted us to take his caution statement. Listen, Martin is saying something differently because he is saying that he wants us to take his caution statement via video conferencing. And I've just told you that even in law, we cannot take a caution statement if the person has not been arrested. And I've gone on to also show to you that you cannot arrest the person via Zoom, let alone take the caution statement via Zoom. We need Mr. Fureta in person. And it's not true that the OSP has delayed. We have our timeline of investigating. For you, you may think that the OSP has delayed. For us, we may not think we have delayed because we ought to take our time and do. And Fureta is not the only case the OSP is investigating. As I speak to you, over 30 people are on bail. Soon they will be arraigned before court. We have so many things we are doing. So the prosecutor and the investigator has his timelines of what he's doing, and he says that he needs the person to come before him. You don't know why he needs the person. And yes, you have a right to know. But at the appropriate time, when we are now very clear that nothing compromises that investigation, we inform the people of Ghana. In any case, the USP stands out as one of the most transparent law enforcement agencies. And all of you can bear testimony to that.
Okay, Mr. Akon, so I want to ask a question. Since you said you need him, he has a right not to incriminate himself, right? So you can get
law enforcement agency. So the suggestion that we could take Mr. Fureta via Zoom may not apply because we cannot arrest the person through Zoom. We cannot take a caution statement from a suspect through Zoom because the only time you can take a caution statement is when the person has been placed under arrest properly, so-called.
Right.
And let me also address the little issue about trying absentia. If you study our constitution very well, Article 19.3 details how trying absentia should happen. And the conditions are about two. It says that when a person, an accused, when you say an accused, it means that you have been arrested, charged, has a disruptive behavior, such that placing him before the court will disrupt proceedings. Or if the person, having been charged, that is, the accused, being placed before court, elects not to come to court at all. So there's a popular case called Kwachi, that is the Republic, which is like the case on it even ended at Court of Appeal. The whole idea is that the person must be tried in his presence, unless that person facing trial elects to say, I don't want to attend the trial, right? But we also do know that, so that's why it will even take international court. And it's the same principle across international courts of human rights matters. If you take the ICC, for instance, why do you think that they issue arrest warrants for people and put them on interpool, heads of state, former heads of state? Why? Because they could try them in absentia. So why don't they try them in absentia? But they still insist that they should have been arrested and he's an accused person, which means that Mr. Fureta has been charged. He has been arrested and charged. So they will talk about why the OSP not taking advantage of mutual legal assistance program and go and do video conferencing, blah, blah. The OSP is aware of all these things. But these things are used when a person has been arrested, charged, and placed before a court. As we speak, Mr. Fureta has not been arrested by any law enforcement agency. So the suggestion that we could take Mr. Fureta via Zoom may not apply because we cannot arrest the person through Zoom. You cannot take a caution statement from a suspect through Zoom, because the only time you can take a caution statement is when the person has been placed under arrest properly, so-called.
Right.
And let me also address the little issue about trying absentia. If you study our Constitution very well, Article 19.3 details how trying absentia should happen. And the conditions are about 2. It says that when a person, an accused, don't say an accused, it means that you have been arrested, charged, has a disruptive behavior, like that placing him before the court will disrupt proceedings. Or if the person, having been charged, that is, the accused, being placed before court, elects not to come to court at all. So there's a popular case called Kwachi, that is the Republic, which is like the case on it even ended at Court of Appeal. The whole idea is that the person must be tried in his presence, unless that person facing trial elects to say, I don't want to attend the trial, right? But we also do know that, so that's why it will even take international court. And it's the same principle across international court of human rights matters. If you take the ICC, for instance, why do you think that they issue arrest warrants for people and put them on interpool, heads of state, former heads of state? Why? Because they could try them in absentia. So why don't they try them in absentia? But they still insist that they should have been arrested and brought. So if you say Slovakian, Milan Slovak, one of the presidents, after he had been arrested and placed before the ICC, he then elected and said, I won't come to court again. Then they decided to try him in absentia. Why is it a win to me? Did not tell Yoku that you have evidence against me, I'll go to court and try me. You don't need me. Why is that today Ghana police have arrested several people, hundreds of people? Why are they not telling Ghana police that, oh, please, if you have evidence against me, go to court and start the process. I don't want to come there. Please, it is not so. Let's not, in our haste of trying to still pin an error on an agency. Agencies are not perfect, but rules are rules, laws are laws. And the OSP has tried to abide by the law. Now, let me address this issue by Ofori in terms of whether they brought us a medical report or not. Ken Ofori, as we speak today, has not brought us any medical report. What Mr. Ofori has brought us are 2 things, and I will expatiate on the first one. The first one was that on the 28th, through his lawyers, Mr. Ofori did bring a letter from his lawyers, a very terse letter with no attachment. And the letter just read, and the SP read into the letter, but people may not have paid attention. The letter just said that we want to thank you for your indulgence of our client. 1, they even acknowledge that we have indulged their clients. And then 2, they proceeded to say that our clients will not be able to come on June 2nd. Then 3, they proceeded to say that our client will go and do a surgery, a cancer surgery. Then 4, they said that if the office is so minded, they can meet us and allow us to see his biopsy. What it means that they want us to see his diagnostic procedures. Then the last one, they said that, or in alternatively, they can seek permission of the court and allow us to see it. Then there was no other attachment. Then the second letter, which many of you have, before we could see any letter, they had already put it through Assassin Radio to everybody. Apparently, they had filed a supplementary affidavit in an ongoing human rights action that Mr. Ofori had filed against the OSP, in essence trying to say that the OSP cannot declare him wanted without a warrant. Now we are producing court that we wanted to arrest Mr. Ofori based on a warrant from a court. Now they filed a supplementary affidavit apparently on the 27th. But remember, on the 28th, a day before, we were in court with them over an injunction application. They were seeking to injunct us from arresting him without a warrant. And that procedure, when they were there, they never brought it to the attention of the court nor the Office of the Special Prosecutor that they had even filed a supplementary affidavit for their old case, which they filed in March somewhere. Now, this supplementary affidavit, we saw it, I think, Tuesday or Wednesday. That's when the bailiff served the office. Now, when we even look at it, it's the same letter they've attached. Now, when you look at it, it's the same letter they've attached and there is no diagnostic procedures attached. And yet, when you see the letter you just displayed, you see at the tail end that they have enclosed something. They said some medical report and another report. Now, these two reports, they are missing in the entire supplementary affidavit they filed in court. It's not part of it. So the exhibit does not include even that diagnostic procedure. But we are not so minded by these diagnostic procedures.
And he still will be silent.
What is in the arrest?
So what would then
but
the arrest be?
I just told you what you just told me, that Mr. Furiata can even decide not to talk. It's not our business.
Yes.
For investigators and prosecutors, that's not our business.
Yes. So what will be the consequence of the arrest?
And you want me to be able to tell you what you need him for. And I'm saying that I cannot even disclose.
There is no. Listen, let's come in this. Mr. Dako, Sabi Dako. Which our constitution doesn't say that, right? You see, when you say arrest is touch and then inform him the offense is committed. That's the arrest, right? Now, he's not here to be touched and informed. What in the Constitution prevents us from saying that, listen, so because you are not here physically to be arrested, we are going on that, look, we would, we have a case against you, X, Y, Z. So let's go on to the next process. This touch and inform him. That's the arrest. So in law, touch and inform him that we are taking you for this and that. Do you need to take him into custody before you do anything? What is this restrictive interpretation of the Constitution? What? Okay, touch him and inform him.
I'm not going to have anything, any banter with you. I'll answer the post now. What you have just said is not new from what I just told you.
But you said with the arrest, you cannot go on with the rest of the process.
You just made a wrong assumption. And I've just told you now that your assumption could not be true.
But that's different from saying that with the arrest, you cannot
do. You are in the studio. When I'm talking, please allow me to talk. Give me that chance. You've got the chance to make this point over and over. I just had the opportunity to address.
Okay.
So if you could just allow me to address. I've addressed you specifically that Mr. Furiata has requested for his caution statement to be taken on the internet. We have said that throughout the law, if you don't arrest a person, you can't even take a caution statement. You will not now tell us that we should do that, because you are the same people that when we don't follow law, the slightest loophole, lawyers will take advantage of it. Allow us to do our job. We know what we are doing. In fact, we know what we are doing. And nobody is infringing on the rights of anyone. Mr. Furiata, if he is not incapacitated, should be able to attend to a law enforcement agency. There are several things that happen inside. You have no idea what happened when Wuntumi entered Iyoko. You have no idea. We may assume. Allow the investigators to do their job.
Work under the scope of
I have to go. But
yes, but then I know you're doing. So yes, I know you're doing. But yes. A quick intervention I wanted to make. Just a quick one.
No, not a quick. Give me my time.
You have your time, but just in the
I want he should finish. But give me my time.
He's done. He's done.
Yes, he's done
with him now.
Thank you. The OSP is a public institution.
Yes.
And they have laid down procedure to handling these matters. We're all trained in the law. In criminal procedure, we know what we must do. Arresting a suspect, cautioning the suspect, making a prima facie determination, and proceeding to charge and arraigning the suspect is only one option provided under law, Act 30. It's only one option. That is arrest, then charging, arrest, cautioning, making a prima facie determination, issuing the charge sheets, and then arraignment. It's only one. The other option available is that you can actually proceed against a suspect, then making a prima facie determination without even seeing the suspect, based on the facts and the evidence. Charging the suspect, preparing a charge sheet, and filing the charge sheet in court. The charge sheet would now be served like a civil process on the accused. If he lies, you shouldn't appear in court on the appointed time. Other procedures provided under Act 30 would kick in. A warrant of arrest will be issued, directed at police officers or a certain police officer or certain police officers to effect arrest of the accused person. When the accused person is arrested, he will then be brought to court. Do you know why bail? Do you know the jurisprudence behind the grant of bail or denial in this country? It's about whether, as an accused person, you will not be a fugitive of justice. You will not be willing to defend your interest in a matter. Whether you will interfere with investigations into a matter. Or when you are on bail, you will go and commit further offenses. If you can demonstrate all this, no court will hold you. No court will hold you. But if you demonstrate any or all of this, that you interfere with further police investigations, you are capable of committing further crimes, and that you will be a fugitive of justice, you are not willing to attend court to defend yourself in the matter, the court will hold you perpetually. But forget about your rights. So these are options available to any prosecutorial agency in this country. So Sami shouldn't tell us that, do we know why they want Ofori within the presence of OSP? Why are you going to torture him? What are you going to do to him? Why are you actually asking Ofori to come? If you know that you can do any of this. They are wasting everybody's time.
Yeah, I mean, it's waste of time.
They are wasting. They are wasting everybody's time. I'm telling you that. I'm telling you that under Act 30,
have options.
under Act 30, which is the Criminal Procedure Act, there's a procedure to deal with this matter.
What is the procedure?
Procedure is the arrest, asking willy-nilly that an accused or now a suspect be willy-nilly brought to your premises, arrested and brought to your premises is only an option. He just told us that, who even says that they want to take a statement from him. But as a lawyer, he can't speak. As a lawyer and a state prosecutor, you can't speak unguardedly like that. Because we are all interested in the matter. You have other options. I've just enunciated on that. If you are finding it difficult to get to a suspect on a complaint before you, look at the complaint, look at the facts, look at the evidence you have. Preliminary. You can proceed to court by making a prima facie determination. Prima facie determination is not only a constitutional law matter. It's a criminal law matter as well. When a complaint comes, before a policeman will say, I am taking you to court, the law enjoins him to determine whether or not the matter is prosecutable.
Yes.
If the matter is prosecutable, he will then charge you for court. You don't need the presence of an accused to charge. It is only one aspect of the procedure.
So the OSP can actually just go ahead and charge.
Exactly. In fact, you can issue a charge sheet, file it like a civil process. The court registrar will direct the court bailiffs to look for the accused person and serve the process. Serving the process is also a matter of law, all provided under law.
We have said a lot about.
So let's talk law first to underpin the processes. Then we can look at other options. If the person is unwell, why? I've been a criminal defendant, a lawyer in many matters. Accused persons have always been brought to court in crutches.